Is this you? Your parent has been showing signs of forgetfulness, confusion, has trouble understanding things, and just doesn't seem to be the same whippersnapper that they used to be. You go for a visit and find that what was always an immaculate house is now in a state of disarray, and your parent keeps asking you the same question and can't seem to recognize common things. You go to the kitchen and discover what looks like a kitchen fire happened. They tell you it was nothing serious, they just forgot they had bacon cooking on the stove. Or maybe you have a child who is about to turn 18, is severely disabled, and will never be able to care for themselves or provide for their own needs. Or your kiddo is on the high functioning end of the autism spectrum. Is guardianship necessary for one child and not the other? Or maybe you have a child or sibling who has mental health issues. Hi, I'm Antoinette ABONE, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth Metroplex. And today I'm going to talk to you about what guardianship is and isn't. This video is the first in a series on guardianship. Guardianship versus conservatorship. First, the term guardianship isn't used in every state. In some states like California, what we are going to talk about is called conservatorship, but in Texas we call it guardianship. They are the same thing, and during this video I will use the term guardianship since that's what we call it here in Texas. Many people first became familiar with the term and concept of guardianship or conservatorship years ago when pop idol Britney Spears had a very public breakdown and was no longer able to manage her own affairs. At that time, her father was named as her conservator or guardian. Now we'll talk more about Britney in another video called Guardianship, Blessing, or Nightmare. The term certainly sounds like a babysitter at best or an authoritarian figure with financial power at worst. So what is a guardianship really? A guardianship in Texas is a relationship established by a court of law between a person who needs assistance caring for themselves and the person designated to help them. A guardianship relationship can be established for a minor about to turn 18 or for an adult. So what happens when a guardianship is established? What happens when this relationship is established by the court is that the person placed under guardianship is stripped of their civil rights, personal decision-making, and authority to control their money and assets. All rights taken away from them are given to the guardian. But not all rights have to be taken away from the person becoming subject to a guardianship. Now we call that person becoming subject to a guardianship the ward. Now, there are different types of guardians in Texas. In fact, we have two types of guardians, a guardian of the person and a guardian of the estate. Someone who has been appointed to handle financial matters for that person is called a guardian of the estate, and someone appointed to make personal and medical decisions is called a guardian of the person. One person may fill both roles, or different people may serve in each role. If a person has assets that need management, a guardian of the estate will be appointed, or possibly a management trust put in place. If the only funds a person receives are from governmental sources like Social Security or the Veterans Administration, no guardian of the estate will be appointed. The Social Security Administration has a process to appoint a representative payee, and the Veterans Administration has a process to appoint a fiduciary. If someone had appointed an agent under a power of attorney, but a guardian is subsequently appointed, in most cases, the power of attorney will be revoked and only the guardian may have control of the assets of the ward. So what are the legal requirements to establish a guardianship? Well, here in Texas, guardianships are put in place when someone is determined by a judge to be incapacitated. This can be as a result of an accident, an illness such as Alzheimer's or dementia, or an intellectual disability. The person who wants to establish a guardianship over another will need to demonstrate that because of mental or physical impairment, The proposed ward is substantially unable to provide food or clothing or shelter for him or herself, to care for the individual's own physical health, or to manage the individual's own financial affairs. The finding of incapacity must be supported by evidence of recurring acts or occurrences within the 6 months preceding the filing of the application. If the court determines your parent, spouse, or child meets this level of impairment, a guardianship may be granted to allow someone else to step in and take control. Now, it's important to keep in mind, simply making bad choices or using bad judgment is not enough to warrant a guardianship here in Texas. For example, a person may not be declared incompetent simply because he spends money in ways that seem odd to someone else. Also, a developmental disability or mental illness is not by itself enough to declare a person incompetent. The final determination on whether a person is competent or not is made only by a judge and not a doctor. Some incapacitated individuals can make responsible decisions in some areas of their lives, but not others. In such cases, the court may give the guardian decision-making power over only those areas in which the incapacitated person is unable to make responsible decisions. This is called a limited guardianship. In other words, the guardian may exercise only those rights that have been removed from the ward and delegate it to the guardian. In other cases, the person may be totally incapacitated and require a full guardianship. In such cases, the ward will be stripped of their civil rights and the guardian will be given all powers over their person and finances if necessary. To go about filing for a guardianship, you will work with your attorney to prepare an application to the courts. This is not a process in which you can represent yourself. The request to appoint a guardian can be made by anyone. So let's say you have a neighbor you think is in need of a guardian, but you don't want to serve as the guardian. You can file what is called a suggestion of need or information letter with the court. This document triggers a process in which the court initiates an investigation to determine if a guardianship for the person is necessary. The court may appoint a guardian ad litem who will conduct the investigation, or a court investigator will conduct the investigation. Now, this process can also be used by family members who may not be able to retain counsel. In most cases, it is a spouse or child appointed for the role, but depending on the family dynamic, a third party may be appointed. Whether the process is started by someone filing a suggestion of need or hiring an attorney who files an application on their behalf to be appointed as guardian, the proposed ward is not left to fend for themselves. In Texas, the court will appoint an attorney to represent the proposed ward in the proceedings. The proposed ward can also hire their own attorney. Now, as I previously mentioned, guardianships are very serious because a person who becomes a ward, like Britney Spears, who we'll discuss later in another video, loses their civil rights. In a guardianship of the person, the ward typically loses the right to vote, drive, marry, decide where they live, and decide what medical treatment they receive, amongst other things. In a guardianship of the estate, the ward loses the right to manage their own assets. Because of this, the courts will look for less restrictive alternatives. Less restrictive alternatives would involve creating necessary trusts, powers of attorney, advance directives, and pre-need designation of guardian. By doing a pre-need designation of guardian, you remain in control of who gets the significant authority to take care of your person as well as your finances. But equally as important is the fact that this document allows you to disqualify someone from serving as your guardian. So watch my video in which I discuss this document. If you have these in place, you will minimize the court's involvement in the guardianship process and possibly preclude it altogether, because the person named within the documents will already have been designated to serve in the role. The great thing about the less restrictive alternatives is, first and foremost, you are the decision maker and not a court. Second, you can do these ahead of time. Talk to your attorney about what you may need and how to put these key legal documents in place to avoid unnecessary headaches and court involvement during periods of temporary or permanent disability. I'm Antoinette Bone, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth Metroplex. If you found this content useful and would like to see more like it, please subscribe to my page and don't forget to tell your family and friends, like this video. And thanks for watching, and I will see you next time.